acknowledgement and they didn't charge or receive VAT tax. I found that just to be an interesting side point as far as no sequitur. One thing to be aware of, at least for U.S. citizens, I don't know if everyone here is a U.S. citizen, but when you are a U.S. citizen, and again, perhaps our accountants will discuss this further, but it's important to realize that as long as you are still a U.S. citizen, even if you are living in Israel, you must report your income to the IRS, and if applicable, pay tax, depending on double taxation treaties, whether you pay the higher tax in one country, you have to supplement. But it's important that you realize that you have to report your income tax. And on a similar note, I don't want to go too far into the issue for the accountants, but if you are a sole proprietor, whether it's a osek moshe or a sequitur, you are subject to U.S. Self-employment tax in the event that you earn income in Israel. That's something, again, when I first was forming my law firm, we originally, again, when you think of law firms in the States, most times you think of partnerships, until we found out from our tax advisors that a partnership would not exempt me as a U.S. citizen from having to pay self-employment tax, which currently is at the rate of 15.3%. I hope that's correct. Yes, that's correct.
What about Europeans?
Excuse me?
And what about European citizens?
I have no idea about Europe. Unfortunately, I'm a lawyer in the States and in Israel. I haven't yet gotten to Europe. I imagine that there's probably something similar, but I don't know. But for purposes of avoiding the self-employment tax, you have to go to the next level of having a company, an Israeli company. You can be an employee of your own company, and you as the employee can be the sole employee and the sole shareholder and director of the same company. But if you want to avoid the expensive 15.3% self-employment tax, your goal should be to incorporate as soon as possible. If we have time, I'll explain, or you may get the impression later on as I discuss it, what my personal suggestion is, which is as soon as possible to form a company in any case. But you can certainly, if you need to, and many people do, start off with a sole proprietorship, and eventually they may move into a more complex structure, such as a partnership or a company. In Israel, a joint venture is, as I mentioned previously, a contractual relationship between two or more parties. It is not a separate legal entity. It is a contractual relationship, usually for a particular project or subject. The first time I came across a formal joint venture was in the early days of introduction of Israeli telecom companies, where you had multiple relationships between a foreign telephone company and an Israeli group wanting to get together to operate or to at least participate in the bidding process for establishing an Israeli telephone company. And usually the preliminary stages of those relationships with a joint venture and not a partnership, because the intention, expectation is not to have a long-term relationship with a separate entity. But a joint venture does not provide any legal entity for which you can formally sign contracts, and certainly both the sole proprietorship and the joint venture and partnership usually does not provide insulation of liability. A partnership, contrast to a joint venture, is a separate legal entity. In most cases, the exception basically being limited partnerships that has its own factors which don't always fall in favor in Israel, but a partnership generally allows two or more people or companies to get together with a formal relationship. A partnership is formed through a partnership agreement and is registered in the Israeli Partnerships Registrar. Anybody that wants to see how a particular partnership is registered can go into the registry of the partnership registrar and see who the partners are, not necessarily the structure, who has which percentage of the interest, but a partnership is a separate legal entity, but does not provide insulation of liability in the event that the partnership is sued for some reason. In contrast, a company, a Tevra, in the states a corporation, is a separate legal entity. It allows, in most cases, for insulation of liability. There are some exceptions to the rule. For instance, the company's registrar was smart enough to put into the Israeli companies law that one of the exceptions to the insulation of liability is obligations of the corporation for obligations to the company's registrar. So, for instance, an Israeli company similar to an Israeli partnership has to pay annual registration fees to the company's registrar. If a partnership or a company fails to make the payments that are required by law, the company's registrar or the partnership registrar has the authority to go after the partners or the shareholders or directors who were responsible for making the payments. Similarly, you have reporting requirements, annual reporting requirements to the registrar, and both of those are personal obligations, at least of the directors, and in most cases of the shareholders or partners of the business. An Israeli company has the opportunity to shift the tax burden from the individuals to the company. What I mean by that is, in a sole proprietorship and a partnership, the income of the business is generally directly attributable to the partners or the sole proprietor. In the case of a company, the company has the opportunity to retain earnings to be charged tax at the corporate rate for corporate taxes, and only the income which is distributed to the shareholders in the form of a dividend would be taxable to the individuals, or if the individuals are employees and get salaries from the business, so they too would be subject to tax at that rate, but you can retain earnings in the company for long-term growth. Let's say you want to buy your office in the future, you want to buy more equipment, you can keep the income, the revenues that you generate in the business, as opposed to necessarily distributing it to the individuals. Israel does not currently have an Israeli equivalent of a LLC, a limited liability company. In the States, to the extent that you have, and this is one of the subjects we're not going to talk about, whether you should incorporate in Israel or abroad, that has many ramifications for many different issues, including taxes. But in the United States, there's a limited liability company which acts as a company for insulation of liability purposes, but for tax purposes is considered a flow-through mechanism to have income attributed directly and losses directly to the shareholders, and under some circumstances that can be beneficial as well. Some of the benefits and reasons for incorporating, as now you're getting an idea of what my inclination is, you should incorporate as soon as you can, if you can. When you have investors.
So, but then, once you, on 15.3%, wouldn't you have to determine, don't you have to evaluate?
We'll discuss that perhaps at the end. If you just touch upon this question, if you have an Israeli company which is considered a separate legal entity, and you are an employee of your own company, even if you are, as you see here, you can be the sole shareholder, sole director, and sole employee. For U.S. tax purposes, you are considered an employee, so you are exempt from the 15.3% U.S. self-employment tax.
Well, but you're still going to pay taxes.
We're going to handle
Still
the
going to
question
pay taxes, but not the 15.3 self-employment tax. When you are dealing with other businesses and business opportunities, perhaps this is a prejudice of other businesses, but they take companies more seriously, from my experience, than sole proprietorships or partnerships, and they come to expect oftentimes to have a company. However, if you have a small business, you're a sofer, or you have a store, and it's not something that would subject you to the likelihood of personal liability, and you, and collection comes to you may not find the need to rush out and incorporate. Incorporation is a somewhat expensive process. Obviously, a sole proprietorship is going to be the least expensive because you don't need a lawyer to help or an accountant to help you become yourself. A partnership, you do need both a lawyer and an accountant. You need an accountant in any case. Thank God for the accountants. You probably need a lawyer in any case as well. You may or may not. You probably will not get to it. But a sole proprietorship is yourself doing business, so you don't necessarily require a lawyer. A partnership you do, a company you certainly do, to incorporate you do, so it's more expensive as you go up in these various levels of structure, but you can do business as a sole proprietorship, although it may not be advisable depending on the circumstances. I mentioned previously a not-for-profit charitable company. Again, I'm combining these two together. They are different, slightly different structures of the same concept, something that's intended for the public good, a charity to advance. We've had clients who form not-for-profits to address various illnesses and parents of children with various illnesses, music festivals, etc. You may have a not-for-profit or a charitable company, which would be the mechanism for doing it. Again, a charitable company, a chalatz, is an Israeli company for all intents and purposes, even though its goals are for the public good. They are subject to registration in the case of a chalatz at the company's registrar. In the case of an amutah, a not-for-profit organization, the amutot registrar, they're subject to giving annual reports and audits, subject to audits, and they can both have employees with reasonable salaries and terms. The more unreasonable the salaries and terms for the employees, which can be yourself, the more you are exposing yourself to an unpleasant audit from the tax authorities, because the goal of having one of these organizations is not to earn a profit for the business or for you yourself, but rather to do the public good, even though they recognize that in order to get people to do that, they have to pay them some kind of benefits. Those of you who may recognize some of these people, which is my way of introducing the next subject, which is business licenses, not driver's licenses. Just to speak briefly, any of these business structures, it's important to realize, you may have to get a separate business license in addition to forming your business. The purpose of getting the requirement, usually it's a municipal requirement to establish a business, is to protect the public from not having adequate quality in this provision of services, something that might be a risk to the public. I'm not going to go into all the, you can see for yourselves, and those of you who wish afterwards to get copies of the presentation, you can look at it in more detail. But here you have a list of 10 categories of businesses that require separate licenses. You will not see here, for instance, a law firm. A law firm, as an example, is subject to the supervision of the Bar Association. For that reason, I mentioned previously about my law firm becoming formally a company as opposed to a partnership, and that is true. However, it is a special kind of company. It's a company which does not have limitation of liability. The Bar Association basically says that lawyers have to stand behind their own acts and liability, and you cannot hide as a lawyer behind a company with limited liability. So yes, for U.S. tax purposes, I am a company and therefore not subject to self-employment tax, but for a liability perspective, in the case of lawyers, we're subject to the supervision of the Bar Association and are subject to having a company without limitation of liability. As I'm running out of time, as I expected, just to touch upon some of the differences as yourselves being a sole proprietor versus an employee. I get inquiries almost on a daily basis from primarily Olim, but not necessarily Olim, people that are in communication with a quote-unquote employer, and they come to me and they say that I'm working for this company. They told me I'm going to be a consultant, a freelancer. You know, what's the story? They're not giving me vacation days. They're not giving me sick days. If I don't show up, I don't get paid. Well, there are significant legal differences and distinctions between an independent contractor, a freelancer, and an employee. As Sri mentioned, it's a whole separate lecture that I give, other people give. But the courts will, if they have to make a determination as to whether or not your relationship with this other entity is one of employer-employee, which if you are the employee, you have certain benefits, and there are implication of obligations on the part of the employer, but the courts will look and see the totality of circumstances as to the relationship between the parties to see whether or not you are in an employer-employee relationship, whether you have to be there 9 to 5, whether you have the ability to provide services to others, whether they provide you automatically with social benefits that would be expected of an employee, whether there's an written agreement, which is only one of the factors that say, usually when I'm writing a contract on behalf of the employer, the service provider that's retaining the services of an individual, and you want to make sure that you're not subject to all of the obligations of employer-employee relationships. One of the things I do is have a contract between the entity and this individual, saying, usually in very bold print, there's no employment relationship being established, sole independent contractor, not entitled to any benefits of social benefits of an employee. Again, depending on what side of the table you're sitting on, you may want to be considered an employee, you may not want the other side to be considered an employee. But if there is a dispute between the parties, usually it'll be resolved in the labor court. Contracts, unfortunately, I'm not going to have a chance to go into any detail on this, but one of the, I'll try to speak quickly. One of the other areas that I find people most get into trouble with, not only in business relationships, but leases, almost a day doesn't go by when I get a comment from somebody who entered into a lease as a tenant, and they didn't hire a lawyer, and now all of a sudden they're having a dispute with their landlord, and what are their rights? And the answer is they were taken advantage of by their lawyer, or by their landlord, who probably did have a lawyer who was aware of some of the way things work in Israel. Regardless of the business form that you adopt, in my opinion, you are well advised to have proper contracts, to spend the money on having a lawyer, it doesn't have to be me, but having a lawyer come and review and prepare the contracts to make sure that it's done correctly. In Israel, there are two aspects that people from the States are not as familiar with. One is that you do not need legal consideration in Israel as you do in the States. For instance, you have a duty of negotiating, performing contracts in good faith in Israel, which is not necessarily the case in the United States. And similar to both countries, you can have an oral contract, which is in most cases as binding as a written contract. One of the problems of an oral contract is they're oftentimes difficult to prove. But presumably, if you're in, we'll have to wait till the end. If you're in a contract and you have a dispute and you get on the witness stand and the judge asks you, did you say that you will do X, Y, and Z? Presumably you're going to tell the truth, and the court will generally, with some exceptions, hold that there is a contract. Just yesterday, somebody contacted me, actually through Facebook. I actually have a site on Facebook, Ask an Israeli Lawyer, so I have to go with that. But I did get a question yesterday. Somebody had an oral contract with a landlord, but they didn't yet sign the contract, and they wanted to back out, and the landlord says, well, you're subject to the contract. And they said, well, I didn't sign the contract, and I had to explain to them that at least contracts which are less than for a period of 10 years, a real estate contract, a lease for a period of less than 10 years, does not have to be in writing, does not have to be registered, and is fully binding. And again, I told this person, I'm not aware of the particular circumstances, but they need to be alert to the fact that having an oral contract can be binding, and they would have been better off either not committing orally or having a lawyer do a proper written contract. Contracts come up in all kinds of relationships between the parties regarding employment, office space, leasing either equipment or